Welcome to CareTalk, America's home for incisive debate about healthcare business and policy. I'm David Williams, president of Health Business Group.
And I'm John Driscoll, the CEO of CareCentrix. Hello,
hey, John.
David.
We're going to talk today about retirement. Not your retirement, not my retirement, but Associate Justice Stephen Breyer's retirement from the Supreme Court of the United States.
Well, I just want you to know that I'm not going to be retiring at all about this subject. I think Justice Breyer, Stephen Breyer, remarkable life of public service, remarkable wise man. How are you going? I suppose you're going to find a way to pick a fight here,
I'm sure
David, but not on my watch.
I'm sure we'll have something to fight about. We may save it for the confirmation for the next justice. But let's take some time actually to talk about Stephen Breyer and, frankly, about a different era that I think in some ways was a better era. Now, one of the things that Justice Breyer and you have in common, I think, is that he was actually an aide to the late, great Senator Ted Kennedy. I think you were as well. Am I mistaken?
Yes, I was sort of about as low a level aide as possible. I worked in auto pen, which meant I made sure the pen didn't fall out of the machine, and I delivered coffee when I was a college student as an intern in Senator Kennedy's office. But I did have the opportunity to observe just the kind of talent that Senator Ted Kennedy was able to actually bring to the office. And Justice Breyer, who I think it was prior to him becoming a district judge in Massachusetts, but post the fact that he was working he'd been a professor at Harvard Law School, was one of many people. But I will say he really stood out for his kindness, his civility, and sort of a wry sense of humor. And even then, you could tell this brilliant jurist, this kind of Harvard Law kind of professor, was super practical. And I think that played out in his long legacy. I mean, he's almost as old as you are, David, at 83. I mean, he's the oldest jurist on the court, and he does represent a different era. And maybe we should dig into
John,
that.
I know you were trying to pick on me there. I won't take it personally if I look this good at 80.
Well, your hairline is very similar to Justice Breyer.
Very much very evocative. I know. I was going to wear my robe today, but in deference I didn't. But John, back when you were in Senator Kennedy's office, and along with now Associate Justice Breyer, one of the things that I remember from that time was that listening to the radio in Washington, D.C., where I had grown up, is you'd have every week you'd hear a debate. They do it on the radio. Ted Kennedy and Orrin Hatch, a very conservative member of the Senate from Utah. And they came from different perspectives, for sure. They didn't agree with one another, but they actually worked together really well and crafted some legislation, worked together. And I think that Justice Breyer was part of that whole spirit.
Oh, very much so. He very famously, when he was the majority or minority counsel, that relates to whether they're Democrats or the Republicans are in the majority, and his employer, Senator Kennedy, was the chairman of the Senate Judiciary Committee. He would pop on his bike at least once a week to have breakfast with the opposing counsel from the party, and they would meet to have breakfast and brainstorm about how they might actually broker compromises or make progress on things that they could agree on, full knowing well that they didn't actually agree on much ideologically, but there was a lot that could help the people of the United States. Justice Breyer, and it's come out in some of his writings and some of his speeches, famously said that a dissent is a failure, and that if there's a choice between getting 20 or 30% of what you want and be a hero to your friends, if you were to look for 100% and be a hero to your friends and get nothing, versus get 20 to 30% by agreeing to work with the other side, whether that's an ideas or ideology, he would always say make progress with the 20 to 30%, and that 100% of nothing is a failure. And that is a different approach to law, jurisprudence, and frankly, conversation in the Capitol these days. It is I don't know whether the people have changed or the environment has changed, but certainly all we hear about is the extremes.
Well, John, the 20 to 30% also, I think, is indicative of the fact that Justice Breyer worked under conservative majority most of the time. He wasn't talking about 50 or 60 or 70%. He also believed that the idea that judging requires judgment. I mean, no surprise, but that's that's novel these days, and that's very different from originalism, which is some of the newest justices favor, where they sort of one true meaning, and therefore it's hard to have a compromise. Let's talk about how some of Justice Breyer's philosophy and his approach, and in fact his tact and diplomacy applied in the area of healthcare. But first, I'll ask you, John. I mean, was Justice Breyer important? Has he been important in the healthcare issues?
Oh, he's deeply important. I mean, he in many ways brokered the critical compromise on the court regarding the ACA. But he's been very impactful and influential on women's right to choose and the abortion rights debate, and had some pretty thoughtful approaches to the line between federal and state responsibility on a number of issues, including Medicaid. But just those three are foundational to how we think about healthcare in America today, and all of them reflect aspects of his middle of the ground, left leaning ideology that looked for solutions that were good for the American people. I mean, he was extremely thoughtful about the fact that we've got over 300 million people, and it's remarkable. He talked about this in his retirement, that they agree on anything, and they don't. And so finding that middle ground. So maybe we dig a little bit and just talk a little bit about his healthcare legacy. David, do you want to just share with our listeners a little bit about how the ACA compromise came to happen?
So if you remember, the Affordable Care Act, of course, very controversial, and when the opponents were unable to defeat it legislatively, all manner of litigation began, and it found its way to the Supreme Court. And a key case that arrived at the court focused on the individual mandate in particular, which also tied into people with pre-existing conditions, and also the Medicaid expansion addressed there as well. Now, Chief Justice Roberts didn't want the court to be perceived as political and partisan, and so he actually reached out to Justice Breyer and also Elena Kagan to try to figure out something to do about it. And the result was Roberts voting to uphold the individual mandate, for which he got a lot of pushback among Republicans, and Breyer and Kagan actually agreeing to strike down the Medicaid expansion. That actually fits with some of Breyer's earlier views about the roles of states.
Well, the mandate for the Medicaid expansion, that it would be a requirement and sort of a gun to the head of the states if they didn't accept it. It's a classic example of the skill with which Justice Breyer would find that middle ground where how would we move a policy forward. And it reflected I think, both Justice Roberts and Justice Breyer's belief that that it is not the right role of the Supreme Court really to kind of pick too many political winners, but to try to help the country make progress. And one of the tragic things about the breakdown in civility, conversation, and compromise in ideology is that a lot of these issues that would normally be negotiated, argued about, legislated, and worked out in Congress and the Senate, decided on or signed up by the president, are now kicked over to the court because for whatever reason, people don't feel like they're getting enough resolution. There's not enough progress across the aisle. There's not enough progress, frankly, at all. People know that Congress is broken. And so the court then becomes the Supreme Court, and local courts become the way to arbitrate and actually decide some of these issues. And the ACA compromise is a great example of an American institution that was set up to work with three justices, Kagan, Breyer, and the lead justice, Justice Roberts, finding a way to create a path forward on something that was voted on and supported by the majority of Americans.
Well, it fit well with what Breyer wanted to do and some of his earlier writings. Now, on the matter of being a healthcare wonk, I'm very comfortable. On the jurisprudence, as you termed it earlier, I'm a little less so. But it turns out that some of Justice Breyer's work on Medicare and Medicaid actually had a big impact even before when he was an appeals court judge, before he was on the Supreme Court, and related to Medicare. And there was actually Massachusetts Medical Society versus Governor Dukakis, who we may remember and is actually still around in Massachusetts. And it had to do with whether states could regulate balanced billing. And the idea is that Medicare is a federal program, and so usually what happens is that there's a doctrine of preemption, which usually prevails. And if the feds do something, then the states are kind of powerless to do it. And so
well, explain what a balanced bill is while these Massachusetts Medical Society docs are defending gouging the healthcare consumer. Maybe you could help explain what balanced billing is so people understand it.
Come on. See, I was so focused on the judicial side, I forgot about the healthcare side. So, of course, balanced billing is an unbalanced thing to do. That's the first thing to know about it. And what it means is that a doctor gets paid, or a hospital, and they get paid by an insurance company or the federal government, and they say, you know what? That's not enough. The patient has a balance. I want to charge $1,000, and the insurance is only paying $300. So there's a $700 balance, and I'm going to try to bill the patient for it. That's balance billing, John. And patients don't like it, and insurance companies don't like it either, because they negotiate the rate and say, this is the rate, you accept it, and that's how it is. So a lot of the doctors represented by the medical society said, hey, I want a balance bill. And guess what? The state can't make a rule that says I can't balance bill. And they figured they've got preemption on their side because the feds, it's a federal issue, Medicare, whereas now the state is tackling it. But Breyer said that doesn't count here.
Now, note that this is one of those classic cases where, look, the doctors have signed up for Medicare. They've signed up for those rates in order to take Medicare patients in general. They've said they'll accept the rates. This was just a bunch of local jokers deciding to upcharge the patient. It's exactly the kind of thing that drives me batty in healthcare. But what was really interesting is that Justice Breyer found a way, because it is sort of odd that the state would be able to regulate this program. But to your point, it founded on that issue of the specificity of the preemption.
Yeah, because the feds never really cared about balanced billing. That wasn't their focus. And usually the states deal with physician fee schedules. So, John, there was another thing on Medicaid. Now, it's one thing that, when he was an appeals court judge and he was the judge, he could rule. Now, when he's on the Supreme Court, he had to be part of a coalition and had to figure out how to work with, in this case, Justice Scalia on Medicaid. And this had to do with the feds.
Conservative, the very conservative yes. Justice Scalia. For those who have not been around as long.
Thank you, John. Feeling is mutual. So in Idaho, they set home care rates too low to attract providers, and federal law says, hey, you have to set it high enough to attract providers. And Scalia said, no way federal courts can ever enforce anything to do with Medicaid. Whereas Breyer said, well, that's okay. I'll accept that element, but now let's have a couple of other ways that someone can challenge Medicare on this. One, CMS itself, Medicare and Medicaid services, could penalize the state if their rates are too low, and people could sue Medicare if the rates are too low. So he found a way to make it work while still allowing Scalia to have his hard right view.
Yeah, I mean, again, that opinion of conservative Justice Scalia, who was the lead judge, I believe, at the court at that point, was that it's a states' rights versus federal rights issue. And because, however, the program is truly funded on both sides, Breyer found a way to get a compromise. Now, David, let's talk a little bit about women's right to choose, access to abortion, because that's obviously a hot topic. It's going to be in front of the court. They avoided making a judgment call on that weird Texas sort of enforcement outside of law enforcement around abortion. But you maybe talk a little bit about, as part of his healthcare legacy, what happened when those issues were in front of Justice Breyer, the issues of access to safe abortions.
So generally speaking, Justice Breyer doesn't have one specific philosophy. Looks judgment, judging requires judgment, as we had mentioned before. There are a couple of areas where he's actually very outspoken and dogmatic. One is about the death penalty, which he's against because he doesn't think there's any fair way to apply it. And the other one is about abortion rights. And so this is kind of an exception to his view on judicial restraint. Justice Ginsburg, she outlined a very kind of specific reasons why abortion rights were necessary to allow women to participate fully in society and have their other rights under the Constitution. Breyer hasn't done that, but he's always been very much in favor of preserving the right to choose. Now, there's a case in Mississippi, not the Texas case, but another one. It's coming up this summer where Breyer is likely to still be on the bench at that point. Now, he has been very tough in his questioning with this Mississippi law. And he said, the court's going to lose its credibility if it overturns Roe versus Wade. Some of these newer justices that focus on originalism don't pay a lot of attention to the precedents that have been set. And so I don't think Breyer's going to really change what the court does here. He's really in the minority. But I think he's right that the court can't just start going and overturning well-set law along partisan lines and still have credibility.
Yeah, I think that in the case, I mean, the death penalty one is the one that I'm most intrigued by because he's been very consistent in saying that because it can't be administered fairly, it should never be administered at all. On abortion, it's going to be interesting. Perhaps this will be his opportunity to explain his definition or defense of the right to privacy in this case, because these are I can't imagine an issue that there are. It's hard to imagine many issues where the passions on both sides are as hot and as fierce, and the likely middle ground so difficult to find. If it's really sort of sad as we go in, because the Mississippi case is not the last one. There's 3 or 4 other ones percolating up the courts. This is exactly the time when we need that kind of a justice, a Breyer who's a compromiser and a progress maker, and who understands the danger of relying on, by definition, unrepresentative representative court that has been appointed over time with lifetime appointments to make the hard political decisions that really should be made at the state and federal legislative level. That's what the founders intended. Speaking of judicial originalism. So, David, what about this? What comes next? I mean, there's always a new excitement in DC. What about the process to get a new justice?
John, we're talking about healthcare here, and it's actually relevant because the Democrats have the barest of majorities, and unlike when Justice Breyer was, he was confirmed by an overwhelming majority, something like 88-10. Now it's going to be around 50-50 probably, just because like everything else. And the healthcare thing is that there's a lot of old senators, John. There's a lot of senators older than us, much older even. But there's a few younger. And one of the younger is Senator Lujan actually had a stroke, sadly, and he's on the Democratic side. And so now, the Democrats don't really have a majority. Now they may by the time that things can work through in the Senate is its own complex place. So I think right now the smart money is on Michelle Childs because from South Carolina, and Senator Lindsey Graham in old style, maybe Orrin Hatch style, is actually supporting her.
You just called Lindsey Graham the Trump's golf buddy, who is a tool of the crazy right, a middle of the roader.
I said old style. He actually back in the old. There's some like vestiges. Like you still have an appendix for no real reason. So this is sort of like he's like the appendix of the Republican Party. He still has somebody who. I do not have an appendix. We're not going to get into that. So anyway, many people were born with them. So and some have them taken out, including the old Republican Party. Nonetheless, he supports them as does Representative Claiborne. And so I think that's where the smart money is. We'll have a whole session, I think, when there is a new nominee and talk about presumably her background in healthcare and how it may relate to the court. Right now, honestly, we're just talking about the Democrats are way behind on the court. And frankly, whoever they pick isn't going to make that much of a difference. Don't forget that Merrick Garland's, President Obama's right to nominate somebody and have them considered was stolen by the Republicans. And that's one reason why the court is so imbalanced, and that imbalance is likely to continue for some time.
Well, David, I think that's probably about as much as we know about jurisprudence. So I'm not sure we should go
Let's
much
not push
deeper.
it, John.
But I will say I do think that this is a real loss. I mean, ultimately, politics and administration it's not just the justice that is about judgment. It's also about kind of managing and leading. And this is a loss to the country. And he's an incredibly talented compromiser and jurist, and just a very decent human being. And we are sorry to see him go.
Well, that's it for yet another edition of CareTalk. I'm David Williams, president of Health Business Group.
And I'm John Driscoll, the CEO of Compromise. Please subscribe to CareTalk on your favorite service.